Patriot Act, and that the Justice Department, the Senate, and House got together and passed post September 11th. But also because of the presence of Christopher Finan, who is coming here to do a talk tomorrow at the Hoover Presidential Library on his biography, which was just recently published, of Al Smith, published by Hill and Wang Publishers. So this will be Sunday at the Hoover Presidential Library at
3 o'clock.
3 o'clock, if you're interested. Also, on our panel today is Director of the Iowa City Public Library, Susan Craig, and William Buss, the OK Patton Professor of Law at the University of Iowa Law School, excuse me. So I'm going to turn this over now for the background and everything else to Chris, who is with the American Booksellers Foundation for Freedom of Expression, sorry. And it has to do with, it's a free speech group connected to the American Booksellers Association. And Chris is here.
Thanks. And it's okay, I can stand up and do it from there.
Mm-hmm.
Thanks. I can't, for some reason I can't talk sitting down. I don't know why that is. It's a real pleasure to be here and to have an opportunity to talk about the Patriot Act. And I was going to say I was coming to Iowa City to talk about the Patriot Act, and I was lucky enough to, because of Jim seems like he knows everybody in Iowa City, to get me on the agenda at the Hoover Library. And so I'm going to talk to them about the 1928 election, which was when Al Smith went up against Herbert Hoover. And I don't know if they're going to like what I have to say, but I hope you like a little more what I have to say today. I also wanted to start out kind of on a personal note, because I'm from New York, and that means that that September 11th has a lot of personal resonance for me. And I live in Brooklyn, in South Brooklyn. My office, though, is actually on Fulton Street, which is downtown Manhattan. It's about 2 blocks from the World Trade Center. And I was not actually at work yet when the attacks took place. I ended up stranded in Brooklyn, and basically our office was closed for a month while we tried to patch things up. And my subway stop is only just now come back into service. It sat right at the foot of the Trade Center, and it filled with debris. And it's still a painful thing. It's still painful to, because now I get off the subway now that the stop's open again. And in the old days, you know, most of the people would go to the left and go to the Trade Center, and I would go to the right, go upstairs to Fulton Street. And the people are gone. You know, it's kind of a little ghostly when I get off the train. And then I walk down, you know, to get back on the train to go home at night, and there's a big hole, you know, where the Trade Center was. Certainly the day of September 11th was the most terrifying in my life. I mean, it was nothing but sirens screaming all day long. And it was for my wife, and it was for my 16-year-old son who was at home. So I have a very strong personal reaction to September 11th that is quite, you know, is kind of in my left brain. While in the right brain, what I do for a living is I defend civil liberties, and particularly the First Amendment rights of booksellers and their customers. And it's actually a good balance for me. It stops me from being too doctrinaire, I think, on the civil liberties side. It makes me, you know, very sensitive to the question of how, what's the best response, as well as to the dangers of an overreaction by government. So when I started going back to work, and I had a very real sense of identification with Americans throughout history, or let's say just confining it to the 20th century, who have gone through also great periods of fear. People who were responding in the wake of World War I to the Red Scare, which resulted in the famous Palmer raids, in which radicals were rounded up all over the country, and many of them were shipped back to the immigrants were shipped back to their homelands. It gives me some identification with what people were feeling when the country went to war, when the country was attacked in 1941, and the feeling quickly grew that the Japanese in the West were a threat to the country because of their background, and also to the period of what a lot of other people call the Red Scare, the McCarthy period, when people were cashiered for they're fired and hounded because of their membership in the Communist Party. I have a connection to all that now that I didn't used to have. But having said that, I can honestly say that when I became aware of the USA Patriot Act, which was passed 6 weeks after the September 11th attacks, I was horrified by what its implications were for booksellers, and not just for booksellers, but for free expression in this country. There is no question that the Patriot Act threatens First Amendment rights, and I will give you the perspective from the bookseller's point of view. The first thing, though, that you need to know is how the Patriot Act passed. I mean, the Patriot Act passed in 6 weeks. I think it's a fair challenge or statement that almost nobody in Congress knew what they were passing. It was a bill that was brought to the Congress by the the Justice Department. It was their wish list. It included a lot of things that they'd wanted all along for many years, plus things that they felt they needed. It was essentially negotiated with a couple of senators in the Senate, and it never came up for any hearings. There was no official markup when normally, the senators sit around and offer amendments and try to come up with a compromise piece of legislation. It passed the Senate by a vote of 99-1 within a few days of its introduction. In the House, on the House side, there was a little more discussion. There were again no hearings. There was no opportunity for ACLU or any other group that might be critical of the act to get up and talk about it. But there was a markup, and there were changes in the bill that the House leadership, basically under pressure from the Justice Department, shook off. And a bill very similar to what passed the Senate went through the House. There was no conference committee. There was no reconciliation of the House and Senate bills. It was something that was done by leaders of the House and Senate standing in a hallway. So what we're talking about is a piece of emergency legislation that we are now having to try to come to terms with and understand and to criticize where it needs to be criticized. The act gives government a tremendous amount of power over speech that it didn't formerly have. It defines terrorism in the broadest possible way as anybody who espouses violence is a potential terrorist under the Patriot Act. And a terrorist organization is 2 or more people who espouse this violence together. Clearly, this includes a wide range of potential organizations. It's up to the government to decide. The State Department really decides who is and isn't a terrorist organization. And But if you think about it a little, you can think of many different groups besides the Al-Qaeda that it could potentially apply to. The IRA, sure, the IRA. The African National Congress. They certainly members of the African National Congress espoused violence as part of their struggle against the South African government. Even the Northern Alliance in Afghanistan, the people who took our side against the Taliban, could potentially be described as terrorists. So there's a tremendous amount of flexibility. That's what the Patriot Act is about. It's about giving the federal government as much power as it needs to fight terrorism. These powers can be exercised, for the most part. The group that is likely to suffer the brunt of the Patriot Act are not U.S. citizens. They are aliens who do not, under U.S. Supreme Court rulings, do not enjoy citizenship and do not enjoy First Amendment rights. Having said that, it's still important to point out that they are really almost completely at the mercy of the federal government under the Patriot Act. They can be detained and deported based on their membership in a group that, if it falls afoul of the government and is on the list of terrorist organizations, irrespective of any particular act that they're guilty of. It doesn't matter whether they themselves have engaged in a crime, much less terrorism. Membership in a group that is on the terrorist list is enough to get you in very deep trouble and subject you to indefinite detention and deportation. It also allows the government to exclude people from coming to this country who are members of these groups. Now, the Supreme Court held after the struggle over civil rights following the McCarthy period that membership in the Communist Party was protected by the First Amendment, as long as the person was not themselves implicated in violent crimes, that there was no crime in belonging to this organization. But under the Patriot Act, the government can exclude people based solely on their beliefs and their advocacy. And you may think that only applies to them and that they're people that probably deserve what they get. But the fact is that because they can't come to this country to advocate their position, we can't hear them. So there is an indirect effect on our speech as a result of these restrictions. And it's not theoretical. It's not far-fetched either. I can tell you that we've already been involved. My organization, the Booksellers Foundation, has been involved in defending a bunch of students, a couple of student groups at the University of California at San Diego, who had created on their website links to radical groups around the world, including Kurdistan guerrillas and the Mexican Chiapa movement. And the University of California told the students, threatened the students with punishment if they didn't take these links down to these websites, because under the Patriot Act, they said, the university said, this is a form of material support for terrorism. So we thought that was certainly an overbroad interpretation even of the Patriot Act, and we protested to the university, and they have backed down on that particular demand. But the fight is going to continue there. And of course, if they get their way, if they are successful, the people who will pay the price are those of us who can't read and learn about these groups and what their goals are and can't argue about them. It's Americans who will be affected. So there's an indirect effect of the Patriot Act. There is also a direct effect, which my group is particularly concerned about, and the librarians are as well. There's a standard, a legal standard, which I'm sure Bill can talk about better than me. I'm not I am not a lawyer, and I don't even play one on TV. But there's a legal standard called probable cause, which makes the government show a judge that there's reason to believe that a person is engaged in a crime before they can get the judge to give them a warrant for a wiretap or a warrant for a search or some other kind of investigation involving access to their private information. We depend on this to keep law enforcement in line and to keep law enforcement from prying into our lives unnecessarily. What the Patriot Act does, in part, is it removes the requirement of probable cause in investigations that are related not just to terrorism, but to foreign intelligence. It gives the FBI the right to go to a judge in a secret court and ask for a warrant to access the records of a bookstore or a library or a newspaper or, in fact, any other business in order to advance their investigation. And all they're required to show the judge is that they have a need for this information. And all they have to do, in fact, is to assert the need to the secret court, which is set up under the Foreign Intelligence Surveillance Act to get access to this material. That set off immediate, when we learned about that provision, that set off immediate alarm bells for us because the booksellers, whose experience I'm most familiar with, have been involved for the last 5 years in a fight over growing efforts by law enforcement to get access to book purchase records. This started 5 years ago. Some of you maybe remember when Kenneth Starr subpoenaed Monica Lewinsky's book purchase records. And we were very concerned that to fight that, and we did fight that. We supported the bookstore that received the subpoena because we fear that if people in bookstores do not have confidence that their purchases are private, that they won't feel like they can buy the books that they need and that they want. So the idea that the government can now, on a very low showing of need, get access to these records is deeply alarming. And it is not just bookstores. It is also libraries. It's also newspapers and other businesses. This was an addition under the Patriot Act. Formerly in intelligence investigations, they could get access to rental car records and that kind of thing. But this is the first time that bookstore records and library records have been affected. As I say, these warrants under the FISA, Foreign Intelligence Surveillance Act, are issued by a court in secret. The Justice Department goes in. We don't have an opportunity to make our case. We've won a number of these cases. We won at least the early rounds in the Lewinsky case. We won a major victory when the Tattercover bookstore in Denver was made the object of a search warrant 2 years ago for its book purchase records in a drug investigation. We have been able to prevail when we can get in and talk to the judge about the importance of the First Amendment issues that are involved. In these FISA cases, we don't have an at bat. The order is issued. The bookseller or librarian will receive an order from the court, and not only can they not appeal it, it says, in fact, that they can't reveal it. They can't tell anybody except perhaps somebody else in the library or the bookstore that can help them produce the records about it. So they can't bring it to us. We can't know the APFI, although we've been fighting this now for 5 years. We can't ask them to tell us directly because they would be violating this gag provision of the order. And in fact, what we've said to them is what they need to do is they need to call us and not tell us what they're calling about. We've said that they should call us and say that they want to talk to a lawyer. We feel like they have a right to talk to a lawyer. They can ask us to give them a reference to a lawyer, but they can't tell us what it's about. It's led to some pretty comical scenes so far in which people have not been clear in what they've been wanted to call about and have stopped my heart, as a result. But at this point, we have not had any bookstores do this. We've not heard, even indirectly then, of any FISA subpoenas under the Patriot Act. We hope that's because there haven't been any. We fear, though, that because of the intimidating effect of the gag order, that it may well be that they're just afraid to tell us. So we're very much on the outside looking in this particular area of bookstore privacy. What we are doing is we have filed a Freedom of Information Act request to try to force the Justice Department to reveal how many subpoenas and warrants, et cetera, have been issued to bookstores, libraries, and others under the Patriot Act. Their response has been so far silence. So we have gone to court now and filed this lawsuit, which is what the Freedom of Information Act authorizes you to do. And probably this week we will be filing a request for a preliminary injunction to try to move this along. And something in which we're engaged in with the ACLU and the Freedom to Read Foundation. Just to find out, we're not asking for information that we think in any way jeopardizes national security. We just want to know if there have been any and how many. This is a broad power that we have no way of monitoring if we cannot get access to these numbers. And I think that basically describes our concerns, and I look forward to hearing the library's concerns and also the legal point of view.
Thank you. That was Chris Finan from the American Booksellers Association, and now is Susan Craig. I'd also like to mention that the co-sponsors of this event are the Iowa Civil Liberties Union Hawkeye Chapter and the University of Iowa Chapter, Prairie Lights Bookstore, and the Iowa City Public Library. And now Susan Craig, Director of the Iowa City.
Thank you, Jim. I don't think Jim ever introduced himself, Jim Harris of Prairie Lights Bookstore, and thank him for putting this together and being a great friend of the Iowa City Public Library over the years. I'm here to give the librarian's perspective, and I think I'll repeat a few things that Chris said, but not too many, and maybe the repetition will help you, because one thing I figured out working on this for the last week, 10 days, is the complexity of the Patriot Act and its many ramifications. It's a can of worms, and it's pretty scary. There are several areas that the Patriot Act directly affects the ability of the nation's libraries to do their job. The best known is the use of expanded surveillance powers. Librarians believe, and most states, including Iowa, have agreed by the adoption of privacy protections for library records, that confidentiality of information sought and received in a library is necessary to an open society. The policy of the Iowa City Public Library, supported by the law of the state of Iowa, states, confidentiality of library records is central to intellectual freedom and directly related to the ability of citizens to use library materials and pursue information without fear of intimidation. Confidentiality extends to information sought or received and materials consulted, borrowed, or acquired, and includes internet and electronic resource search records, reference interviews and transactions, circulation records, interlibrary loan records, and other personally identifiable use of library materials or services. Provisions of the Patriot Act threaten patron confidentiality, which is why the Freedom to Read Foundation, the First Amendment legal defense arm of the American Library Association, is joining with other groups trying to find out how the Act is being carried out and to work to change some of its provisions. In an article titled "Things We Lost in the Fire" in the September 11, 2002 Village Voice, the author, Alyssa Solomon, writes, and I quote, A man approaches a librarian to ask for help finding a text. "These books are no longer available," she replies, in a pinched Peter Lorre-like voice. "May I have your name, please?" A couple of suited thugs take the library patron away. The scene comes from one of a series of patriotic public service announcements produced for the 4th of July by the Ad Council, which feature creepy Big Brother scenarios followed by the legend, "What if America weren't America? Freedom. Appreciate it, cherish it, protect it. Trouble is, the library segment is no fantasy. As far as she knows, there aren't yet any goons stalking the stacks," says Emily Sheketoff, executive director of the Washington office of the American Library Association. But under the USA Patriot Act, law enforcement officials can force librarians and booksellers to hand over records of who checked out what books and what websites they visited without the high bar of probable cause required for searches under the Fourth Amendment. Librarians, furthermore, must not tell anyone such records have been requested, not even the patron being investigated. If they refuse to fork over the records, they can go to jail. "What books you read gets very close to what thoughts you think," says Sheketoff. "This is very dangerous." End of quote. Have federal agencies actually used these powers? It's hard to tell. One of the most disturbing things about the USA Patriot Act, in my opinion, is the gag order it imposes on persons served with court orders. A librarian who discloses information about searches is subject to criminal prosecution. I'm pretty sure that I can't get in trouble for telling you that we've received no court orders to reveal how people use the Iowa City Public Library, but I'm not altogether sure about that. The University of Illinois surveyed just over 1,000 public libraries last January and February. At that time, they found 85 had been asked by law enforcement for information about patrons. I have read of instances where public access workstation and servers were confiscated. When this occurs, it obviously has a very harsh effect on the ability of a library to offer the public access to electronic resources. The process by which the FBI gains access to library records is quick and mostly secret under the Patriot Act. To obtain a search warrant for library records, the FBI must show a judge it has reason to suspect a person is involved with a terrorist or a terrorist plot, a less stringent threshold than the tougher legal standard of probable cause required for traditional search warrants. This is not the first time the federal government has gone searching in library records. July 25th article in The Nation by Laura Flanders reminds us that between 1973 and the late 1980s, the FBI operated a secret counterintelligence operation called the Library Awareness Program. At that time, they were most interested in what communist sympathizers were reading in the nation's premier science libraries. Workers in these libraries would be approached, flashed a badge, and asked to prevent the spread of sensitive but unclassified information. It was this campaign that prompted some of the state protections currently in place for library records. This history note brings up another aspect of our nation's response to the terrorist attacks that I would like to speak to, although it's not a provision of the Patriot Act. The issue is one of access to government information. In the aftermath of September 11th, agencies at both the federal and state levels began to take a series of actions that limited or prevented public access to previously available government information. These include the U.S. Geological Service requesting that the government printing office order depository libraries to destroy a CD-ROM on water resources. I believe the University of Iowa government documents section got such an order. The National Archives and Records Administration issuing guidance to its regional archives to screen requests for some types of records. The Nuclear Regulatory Commission shutting down its entire site. Agencies on an ad hoc basis taking down materials from their public websites. The situation is fluid and evolving, with some agencies reposting some information but not all, so it's difficult to know what is no longer publicly available. The Energy Department decided to suppress about 9,000 documents from its Information Bridge web service. Many of them are scientific research papers from national labs that contain key words such as nuclear or chemical or storage. Department employees are reviewing the papers to see if they pose national security risks and are reposting those found to be benign. This process may take many months, and legitimate research may be delayed as a result. The Defense Technical Information Center has removed thousands of documents from online public access. While it is planned for panels of scientific experts to be assembled to assess whether the documents should once again be made available to the public, documents that were never classified may be, and ones that were declassified may be reclassified as state secrets. It should be noted that none of these actions have been taken at the direction of the administration. For this reason, though, there is also no central inventory, no direction, or ensuring the permanence and integrity of the information restricted, and no guidance on weighing the known benefits of public access with the conceivable use of the information by potential terrorists. There is a variety of legislative proposals at the federal and many state levels with the potential to erode the public's right to know by classifying information. For example, the bill to create a Department of Homeland Security includes a provision that creates broad exclusions from the Freedom of Information Act. And again, a broad coalition opposes weakening the Freedom of Information Act. Groups opposing new secrecy provisions include library organizations, environmental groups, civil liberties groups, open government groups, and press organizations. So what, if anything, have we done at the Iowa City Public Library? This library, as do most others that I know of, have had long-standing policies and procedures in place to protect the confidentiality of library records. We always say, if you don't want anyone to know what you've read, bring the materials back. Once items have been returned, the link between your name and what you ever had checked out is gone. We don't keep access to internet records. Keep records of your internet access, people who sign in by their names, which if they don't have a card they have to do to use our internet access machines. Those records are destroyed at the end of the day, and the logs that we keep for statistical purposes that connect patron card numbers to what websites have been visited are destroyed as soon as we've gathered the statistics. I've tried to keep the library board and the staff informed about what's going on at the federal level. It's difficult with all of the deluge of news that comes out to winnow things down into an article. Jim was talking about an article in the Washington Post, I think, that was 10 or 12 pages long if you printed it out. Not many people take the time to read through something that long. So it's our duty, to keep the word out about things like this. I'm not an expert in the USA Patriot Act, but as a librarian and a citizen concerned about the type of society I live in, I feel some of its provisions go too far. In the last 13 months, I have heard this quote from Benjamin Franklin several times. "They that can give up essential liberty to obtain a little temporary safety deserve neither liberty nor safety."
Thank you, Susan. The article she was referring to in the Washington Post, I had underlined that Benjamin Franklin quote because it's so significant, and I think it's just reassuring from what you said is one of the great reasons to live in this town is because of this library. Thank you. And now William Buss from the University of Iowa Law School will speak on legal, constitutional matters.
I want to start by going back to the title. See if I get it right, Jim. The Patriot Act, got it wrong already, versus libraries, bookstores, and you. I got the order wrong. Bookstores, libraries, and you. So, the you in the title of this program is understandably a bit vague. I take it to be not so much you in the audience, but you in the every person sense, every person in the United States. And I don't mean to suggest that this Patriot Act sort of keeps people from buying books in the sense of having a provision in there that says you can't buy a book or you can't buy this kind of a book. It doesn't say anything like that. Of course, I have to say that based on my very limited study of this, I'm quite sure I know at least as little as the people who have apologized before me about this. This is the Patriots Act, but the thing you should know about it is it's just about 90% of it is little amendments of other acts. So we're really talking about a very complicated mass of material dealing with this subject. And I also want to say that I think the Patriot Act is, because of that and because of other things, it's just the tip of the iceberg. So even though that's kind of the thing that generates our attention, it's not the whole picture. I mean to be addressing the First Amendment and freedom of speech in the context of the whole panoply of government and non-government action that is taken in response to the threat of terrorism in and to the United States. And in this connection, I want to sort of try and talk briefly about three things that I think are basic things that you need to know about the First Amendment. Let me just mention first the language. You all know this, but let me say it. Here's the language. Congress shall make no law abridging the freedom of speech or of the press. That's what it says. And we have to understand this as meaning the government shall make no law abridging the freedom of speech. That phrase, which seems pretty definitive and absolute, and it doesn't really mean that. This is not by any means an absolute protection of freedom of speech. As interpreted by hundreds of cases over time, it means basically that the government shall make no law abridging the freedom of speech unless it has a good enough reason to do so. And over time, a very wide array of reasons have been found to be good enough. That may seem odd, but if you don't accept that, then you're not in the conversation about the relationship between the First Amendment and the Patriot Act and the like. And beyond any doubt, protecting the national security may be a good reason for abridging the freedom of speech. Let me give just one example of that touches on an area not too removed from what we are experiencing now. Back in the 50s, many Americans were seriously worried about the threat from the Communist Party because of its subverting or seeming to subvert important aspects of American life and its threat to the overthrow of the government. In a case called Dennis versus the United States, the Supreme Court upheld criminal convictions against leaders of the American Communist Party for being members and advocating unlawful action. Chief Justice Vinson of the United States Supreme Court, applying the clear and present danger test, which everyone knows, has heard of, said the following. The mere fact that from the period 1945 to 1948, petitioners' activities did not result in an attempt to overthrow the government by force and violence is, of course, no answer. The formation by petitioners of a highly organized conspiracy with rigidly disciplined members, subject to call when the leaders felt the time had come for action, coupled with the inflammable nature of world conditions, similar uprisings in other countries, and the touch-and-go nature of our relations with countries with whom petitioners were, in the very least, ideologically attuned, convince us that the requisite danger existed to convict these people on the basis of what they said and advocated. So the first point is not to exaggerate what the First Amendment will do to protect your right to speak your mind or to buy or borrow books. Second basic point, the Constitution of the United States does in fact provide a lot of protection. That's what I've said, how little it provides. I want to say it provides a lot of protection. I mean, I think many people think that our First Amendment is more protective, some people think absurdly more protective than the law of most Western democracies, if not all. But I would add, much of the protection comes not from the First Amendment itself in a narrow sense, but from the Constitution as a whole. Without trying to give a full civics lesson on this, I want to mention three important sources of free speech protection outside of the First Amendment: due process of law, the ban on unreasonable searches and seizures, and the separation of executive, legislative, and judicial powers. So each one of these briefly. It's been a while since I've read The Trial by Franz Kafka, but what I recall is that his problem was not so much that he was prevented from saying anything as that he had no idea what he had done wrong. Possibly it was something he had said, but who knows? They didn't tell him. Possibly he could have explained, but he never had the chance. No due process of law. Now, of course, the classic example that's parallel in the Patriot Act is these people who are subjected to a subpoena for material who can't tell anyone in the world that they have been. And I take it that there's a clear First Amendment problem there. It's a prior restraint on what they say, but it's also a serious problem of the lack of due process of law. One of the things that libraries and bookstores are concerned about is government obtaining information about who has read what books. And that presents a First Amendment issue, certainly, but it also very definitely presents a Fourth Amendment issue. I want to just read a short quote from a Supreme Court decision called the United States versus the United States District Court, which is mainly about the Fourth Amendment. But the court says, national security cases, moreover, often reflect a convergence of First and Fourth Amendment values, not present in cases of ordinary crime. Though the investigative duty of the executive may be stronger in such cases, so also is there greater jeopardy to constitutionally protected speech. Historically, the struggle for freedom of speech and press in England was bound up with the issue of the scope of the search and seizure powers. Turning to the separation of powers dimension of these other sources, the comments of Justice Jackson in a case called Youngstown Sheet and Tube versus Sawyer, very different context, but nevertheless, I think his comments provide a good foundation for why I claim that the separation of powers is another important source of protection for free speech. This is Jackson. There are indications that the Constitution did not contemplate that the title Commander-in-Chief of the Army and Navy will constitute him also Commander-in-Chief of the country. He has no monopoly of war powers. Military powers of the Commander-in-Chief were not to supersede representative government of internal affairs. It seems an obvious from the Constitution and from elementary American history. Jackson goes on, I have no illusion that any decision by this court can keep power in the hands of Congress if it is not wise and timely in meeting its problems. We may say that power to legislate for emergencies belongs in the hands of Congress, but only Congress itself can prevent power from slipping through its fingers. Whatever the exact boundaries, I'm still talking about separation of powers, whatever the exact boundaries between what can be said in times of war and times of peace, it's very clear that free speech rights are legally and practically narrowed during wartime. Here's just one little indication, a statement from Justice Oliver Wendell Holmes, Jr. When a nation is at war, many things that might be said in time of peace are such hindrance to its efforts that their utterance will not be endured so long as men fight, and that no court could regard them as protected by any constitutional right. So, your freedom of speech is critically affected by the extent to which the president is given arbitrary power to make decisions about war, free of meaningful congressional restraint. The third thing you need to know is that whatever freedom of speech you have is a product of the highly specific and the almost ethereally general. By the specific, I mean that it is often case by case. I'll just give one example that I'm drawing from an article that David Cole recently wrote in the New York Times in connection with these 5 young men from Lackawanna, New York, who are accused of being a terrorist sleeper cell. They are being prosecuted for providing material support to a terrorist organization. Now, the government argues that the support is all that is needed, that is the fact of support, and they argue that the attendance at these training camps is all it takes to show support. Cole argues that the Supreme Court of the United States has held specifically that in order to be prosecuted for providing assistance to an unlawful organization, that is, an organization that has unlawful goals, the person charged must specifically intend to accomplish those unlawful goals. The government responds to that, well, that was a case about membership, not about support. And then Cole, in turn, responds that the right of association would be an empty formality if it protected only the right to join groups that no one could support. Now, there's an argument there. And this is an old case. It's actually another one of those 50s era case, although there have been some more recent cases that have cited it. But it's an old case based on the Communist Party scare in the McCarthy era and the response to that. It's not at all inevitable that the courts are going to continue to apply it in the same way. It's not at all inevitable that the courts are going to think it's not distinguishable. It's not at all inevitable that courts won't simply change their mind. The issue has to be fought out in a very specific, one-at-a-time fashion. The courts have to be convinced, and the courts have to be open to being convinced. That brings me to the more elusive general part of what does or does not produce a robust freedom of speech in the United States. If government investigators snoop in the libraries and bookstores of this country, just listening and observing for possible evidence of who is looking for which books, evidence suggesting connections between reading choices and terrorists or terrorist organizations or terrorist support, there may well be a violation of someone's First Amendment rights, though it would not be an easy case to win. But if shoppers and borrowers feel threatened by the possibility of the use of such evidence, or even by the possibility that such snoopers might be around, their taste in books might be affected. And beyond that, the very possibility that there might be such snoopers would be both a reflection and a cause of an atmosphere that is not conducive to the exercise of freedom of speech or its protection by the courts. The conventional wisdom and the profound truth about the First Amendment is that we give freedom of speech its lofty place in our constitutional scheme for many reasons, but the most important of these, I think, is its role, that is the role of freedom of speech, in self-government. Democracy is meaningless without freedom of speech, association, and the press. The theory is that we have to have a right to influence the views of those we elect. We have to have the right to influence our fellow citizens, those who vote. We have to be able to criticize the policies that we don't like. I suppose that theory is pretty self-evident. But of course, there's nothing in the theory that makes us choose wisely what to support and what to criticize. Nothing that makes us speak out at all. Nothing that makes us have courage to brave the risk. Nothing that makes us really want to buy and borrow the books we want. Thank you.
Thank you. We'll open this up for questions here in a minute. And I think the one thing that you said, Bill, that just jars me every time is this idea of war. Has Congress declared war? And on whom and whatever? And this whole Patriot Act, the post 9/11 situation that's going on here, they're just the questions all over the place, and I'd like the audience. You ask a question, I'll repeat it for the microphone for the television thing. David?
You would think that people would be outraged by what's in the Patriot Act. Do you have any theories, any of the panel? Do people not know, or are we at a point where people don't care, or because of their fears actually support some of this? Were you going to repeat it?
Do people not know, or do they not care about the elements in the Patriot Act which can cause concern? I'm not sure I repeated that exactly, but Chris, you want to?
Well, I think for the most part, people don't know. I was sitting in a meeting. It took a while for us to be aware of what was in the Patriot Act, in part because of what Bill was saying. You know, it's not something you read straight through and get. And I was sitting in a meeting with a bunch of other First Amendment types and an expert, actually this guy Jim Dempsey, who was referred to earlier, went through this section 215, which applies to bookstore and library records, and I said, wait a minute, back up? What did you just say? That was, you know, that was less than a year ago. And, you know, since then, there has been quite a bit of coverage in newspapers and about it, but, you know, the fact is still the larger story gets most of the attention, and the larger story is, you know, the nation's battle with terrorism. We did a press conference on the 6-month anniversary of the passage of the Patriot Act. I actually just had a birthday. I don't think we're going to sing here today, but on October 26th was the passage day, or was the enactment date, was when the president signed it. And we held it in Washington in the expectation that we would get more press there. And we had Senator Feingold from Wisconsin, the only senator who voted against it, and we had the late Patsy Mink from Hawaii, who was one of 66 in the House who voted against it, and we had 2 reporters. Everybody's, you know, over at the Justice Department. Everybody is, you know, is focused on the threat from terrorism and less focused on the threat to civil liberties.
Could I add to that? Because it's really an elaboration of what you said, but it seems so important that, you know, to drive this point home, that most, you know, I'm a lawyer. I'm supposed to be able to understand. This is incredibly complicated. It would take me months to really digest all this in an area where I don't know a lot already, because, you know, when you read through here, it doesn't sort of just hit you, wow, this is all about the First Amendment. You have to really sort of, you know, occasionally notice some little thing, you know, like the business, you know, that section 215 that's so important is that the language is, may make an application for an order requiring the production of any tangible things, including books, et cetera, and they name a bunch of things. Well, you know, that's if your eye is out for it, you see that, but it doesn't really knock your socks off when you go through it. And other things are even more that way. I'll give you another example. This is sort of partly to sort of evoke sympathy for lawyers who have to read this stuff all the time, but just listen to this. This is section 218. I'll read you all of section 218 of the Foreign Intelligence Information. That's the name of the section. Sections 104A7B and Section 303A7B, parent, 50 U.S.C. 1804A7B, parent, and 1823A7B of the Foreign Intelligence Surveillance Act of 1978 are each amended by striking, quote, the purpose, end quote, and inserting, quote, a significant purpose, end quote. That's it. Now, that is one of the provisions that I think some people think is a very significant provision. Why is it a very significant provision? Well, you can't tell by looking at just that little bit. The purpose, a significant purpose. What it's talking about is this FISA Act that was referred to, and the Foreign Intelligence Surveillance Court. And the question, of course, is what jurisdiction that court has. This goes all back to law that's developed before the Patriots Act, and the FISA Act, if it's sort of a repetitive way of talking about the A, but the FISA Act and this court were partly created to make sure that there was a separation between the intelligence concerning foreign intelligence and domestic crime prosecution. And so this language about the purpose, you know, what it's talking about is when there's an application for basically for a subpoena to get material, that it has to be for foreign intelligence information. But whereas before, it had to be the purpose was foreign intelligence information. Now it only has to be a significant purpose. So how much does that change? Well, it changed some, and it may change an awfully lot. Anyhow, this is, that's obviously a very long-winded way of saying it is very, very difficult to know this. And so then you add on to that that the nation and to some extent Congress's attention is focused on whether we're going to go to war against Iraq. I realize that I've got the order a little bit out of sequence, but not much. And the point is that there isn't much publicity to any of this, and it is extremely difficult for even really caring and intelligent people to sort of get worked up about it because they just are not in a position to know what's going on.
But I also think that we've come a long way in a year. A
Yeah,
year
I
ago,
agree.
we wouldn't have had this panel, even in Iowa City, Iowa. A year ago, people were losing their jobs because they were speaking out against, what the president said. And so, we've come a long way in a year. And 3 weeks ago, in Newsweek magazine, there was an article about agents, the ACLU maybe? I can't remember which organizations were looking for a librarian to be a test case to break the gag order. And, if that's showing up in Newsweek magazine, it's beginning to get out there. And I think this provision about library records and what you buy in a bookstore are two things that people usually can unite behind and get up in arms, and that can be used to point the finger at other provisions of the Act that people may not immediately realize what's going on. Because it is, people say, you're going to do what with my library records? So we're getting there, I think, I hope.
To me, what's terribly distressing is the fact that our elected representatives passed this with, all of their cadre of people that are supposed to give them information that is digestible about these acts that are, hugely important, and that 99% of the Senate just sort of rolled over and said, okay. Those are people. We do have a responsibility to try and find people that can explain these things to us so that we can act on them because we have some information that makes sense. But our elected representatives, I think it is absolutely essential with all of their support groups, their lawyers and their people that pour through this, essential that they know and are intelligent about what they're passing and going back to the constituencies and explaining this to them. I don't know, it's just very distressing.
Right.
What I think one of the things that concerns me most is that maybe you made it very clear that maybe the bar has been lowered when it comes to information in this society. Of information, money, and power. I believe that information is the most important thing we've got. And because once you control it, you can pretty much control whatever you want. And it's there's a fine line, I guess, between society and personal privacy and public information. And given the complexity of that act, I can't help but think there's a reason why it's so complex and so that nobody can actually understand.
Margaret?
This past week, I was having a discussion with my 12-year-old daughter about civilian nuclear power in the United States, and I went online to look up Savannah River, simply to ascertain when that site was developed and its physical extent. And on the homepage, there's a statement, access to and utilization of this site is monitored for security purposes. Now, I've been a longtime member of the ACLU, and maybe I should be ashamed of the fact that I was so disgusted by that I logged off and truncated the discussion. So I guess my question really is, how do you quantify the extent of self-censorship and the consequences that has for the society if it affects me with a commitment to pursuing that kind of information?
The complexity of the act that you point out and the haste with which it was put on the table, maybe I'm paranoid, but doesn't that suggest that this somebody had this on their agenda long before 9/11.
Oh, I think that's well known, that much of what's in the act was in fact, like much else that's happening in the world, just sort of that, is like, I don't want to come off as a cynic, but it's, there is a certain picture that when 9/11 happened, there were a lot of people who had some smiles among their tears because it was in fact an opportunity to do things that they thought should be done. I mean, and I give them all the good faith, but they were things in many cases that were already on the want list. So I think you're absolutely right about that.
Does the Patriot Act require that records be kept?
The question is, does the Patriot Act require that records be kept? And Susan, I don't know, but I'm kind of in Susan's camp in that we don't keep records of your purchases as a matter of course. I don't know if they can go back into your backup systems all and find it anyhow, but because we delete it. But
to the best of my knowledge, there's no requirement that you keep these records. The part of the problem for us as booksellers was that, particularly my group represents independent booksellers, and we have been preaching, or the trade association has been preaching the value of relationship marketing. We're in a struggle with chains and with internet bookselling, and one of the ways that we had hoped to fight back was to be able to track with your permission what your previous purchases were, as a way of suggesting when new books came in that you might want to come in and buy them. Obviously, this puts that in a cocked hat because it makes us complicit with the government in tracking your records for possible surveillance purposes. So a lot of booksellers are coming to the conclusion that they can't do this, and unfortunately, it's going to hurt independents most because they're the ones who've been the greatest advocates of this.
Just wondering how all the discussion centers on freedom of expression, but I'm wondering, is there another way of thinking about this in terms of freedom of consumption? And are there laws that are related to rights to buy and sell legal products that are that you could say that the law has a chilling effect on the right to purchase?
it's a very good question. Is there freedom of consumption rather than just expression as it comes down?
No. There is, in the sense that we're a very free society, and we have the freedom. And I said this at the beginning of what I was saying about freedom of speech, that we have freedom of speech until the government has a good reason for telling us that we don't, and that's true of every other freedom. But it's also true that with respect to freedom of speech, the government has to have a much better reason, whereas with respect to freedom of consumption, they just have to be acting in some way that is not totally bizarre, which is pretty hard. It's a pretty hard line. So I would think that you'd have to tie in the freedom of to consume what and bring in ideas, speech, and so on as a way of making that a meaningfully protected right.
The question of what records bookstores keep is more complicated than simply, do you keep a record that Joe Smith bought a copy of Mein Kampf? That's, if you actually kept that record like libraries do when I check out a copy, then you would have something to destroy that would be useful. The more dangerous thing with retail sales these days is that the credit card has a record that someone spent $12.50 at Prairie Lights Bookstore on September 23rd, and Prairie Lights Bookstore has inventory records that say that a book with tax that had a value of $12.50 was sold on September 23rd, and an intelligent data miner, and that's what this profession is being called these days, an intelligent data miner can start putting two and two together and reconstruct what books were sold to who on that day, as long as people use credit cards. That reconstruction is well within what people can do these days, and particularly for the smaller bookstores that have records for this location, as opposed to places where we consolidate the records for a number of chains by the time it gets, for a number of outlets by the time it gets to the credit card company. You could well have this information even though you don't know you have it. And so they might subpoena purchase records, they might subpoena the inventory transaction records from a bookstore and the record of cash flow from the credit card company, and then put two and two together. It's very different from the supermarkets with the barcodes, and you have your Super Saver card that gives you a coupon worth 5 cents every once in a while in exchange for using that supermarket and letting them know everything you buy.
I never heard.
Right, but a bookstore, they can't do the cash flow, and I mean, that's way beyond over their head. It's an abstract concept, thank God.
Well, your inventory records are pretty accurate.
I know, I was
That's
just
the
trying.
trouble.
I'm trying to make that go away, but you just
I
said.
hate to admit this in front of you, Jim, but one place that does keep track of what you buy is Amazon.
Mhm.
Every time you go in there, they'll tell you, don't you want another one of these
Right.
kind of records or this kind of book? So they can just list them right down.
They have
It's
had
on
some run-ins, incidents with all sorts, it's actually fairly interesting. I don't know where to direct you to read about it, but it's,
On our website.
you're, okay, there.
Yeah.
And they've actually
Amazon.
stood up, I think, and.
One of our pre-Patriot Act fights, it wasn't our fight, it was Amazon's fight, but we were ready to weigh in if necessary, was that the Cleveland Police Department asked Amazon to give them a record of everybody in northeastern Ohio who had purchased 2 particular audio CDs. And they got not one, but 2 judges to sign off on the search warrant that got served on Amazon. And it was only, it was because the final search warrant had to be issued in Seattle, where Amazon is based, that Amazon was able to sit down with the prosecutor and say, you don't want to execute this warrant. But that's the kind of, when I was referring to the growing attacks on customer privacy, that's what we have seen increasingly over the last 4 or 5 years.
I got the impression from Mr. Feynman that the Justice Department had been wanting to do some of these things for many years. Under the Clinton administration, I don't know about justice, but certainly some aspects of the government, the presidential order affecting the use of the Freedom of Information Act and the 20-year period after which government records should be released, these things were interpreted liberally. And from the Department of Energy came a flood of amazing stuff about the activities of the Atomic Energy Commission, the most invidious organization ever spawned by that monster in D.C., was available. So I can't see that anything, what was the Justice Department under Clinton different from the rest of this?
I recommend a book to everybody. It's called Terrorism and the Constitution by David Cole and James Dempsey, which I had never read most of this stuff. It includes a history of the passage of counterterrorism legislation under both over the last 50 years, including, and the last major act was under the Clinton administration in '96. There are big differences between the Bush administration and the Clinton administration about freedom of information. And I guess what I meant was that there have been advocates of strengthening the power of the Justice Department to get access to this information in all administrations, but they really came to the fore in this administration. This is the administration that didn't want to comply with the Presidential Records Act. This was the administration that put the burden on the people coming forward to file Freedom of Information Act requests. Yeah, And the other thing to note, and it's noted in the book, is there are provisions of the Patriot Act that don't even relate to terrorism or foreign intelligence that and are permanent. That the section that the booksellers are most concerned with, 215 in the library, that's supposed to sunset in 4 years. In 2005, it's supposed to stop. But there are permanent increases in the power of the administration, the executive branch, as a result of the Patriot Act, that are clearly just things that, it was a Christmas tree. They went around the Justice Department, and they said, what do you want to see? This is the time to get it. And, you can't blame them for taking advantage of their moment. I mean, this is the nature of a bureaucracy.
Well, I've heard there are some efforts in the FBI to, in certain cases, suspend habeas corpus, which, I don't know if the Patriot Act would apply to that or not.
Well, I'm not sure, legally I can't talk about any of this because I'm not knowledgeable enough, but there are a number of, I think it was in this book somewhere, but there are a lot of people incarcerated now, which is to me, it's a complete suspension of habeas corpus. They don't, and this is on this, what you referred to earlier. 1,000, is that the right number of basically men who of Muslim connections? So not even, and that's a big broad one because does it come from Southeast Asia? Does it come from the Middle East? Whatever. North Africa, and they're incarcerated, and they're a lot of them still are.
The 1,000 you mentioned, I believe, are non-citizens, and I think there are some questions about to what extent the Bill of Rights applies to non-citizens. But there have even been a few citizens who've been incarcerated who haven't been given access to a lawyer. I mean,
they haven't been charged.
They could come in here and grab any one of us.
Have been charged.
And make a very broad accusation and lock us up for as long as they wanted to. And
That's not based on the Patriot Act.
There was somebody recently told me there was a mental health bill that just went through House of Representatives, and they can do that. They just have to show that basically you're a danger to yourself or somebody else, and they can lock you up indefinitely.
Let's get it down to two more questions. Mike?
Yeah, this relates to something Bill mentioned. Noam Chomsky has made the point repeatedly that freedom of speech is freedom of speech, period. It's an absolute standard, and so according to your remarks, he would be out of the conversation, right? So I wanted you or anybody on the panel to react to that proposition.
Well, I ran across it in this clear and present danger thing going back to Oliver Wendell Holmes. I mean, he just hit me over the head. I had no idea. This goes back 100 years, or maybe longer.
About 80.
Yeah.
Okay, that's your question is a good one, because I said you'd be out of the conversation, and what I mean is that you'd be out of the conversation about what the law is and what any serious thinker about what the law is going to say. I'm not at all saying that someone couldn't make a case for an absolute view of freedom of speech. I think it's a hard case to make personally. And let me add one other thing along these lines. There is a problem with this kind of a gathering that we're sort of all preaching to the choir, one could easily imagine that if we had some different third or fourth person on this panel who had a total different perspective, a lot of these things that we're all agreeing about wouldn't be so easy to agree to. And the reason why the law has evolved the way it has with respect to the First Amendment and every other piece of the Bill of Rights not being an absolute is because there are strong arguments for limiting speech in certain circumstances, and there are other interests. We're not a kind of mono-dimensional society. It's not the only value that we have, and so I think I wouldn't want it to go unsaid, and I guess that's why I'm talking at the moment, that there's nothing that could be said for some of the provisions in this act or some of the other acts that are, I mean, terrorism is a real problem, and it's a problem that this country has to deal with. And it seems to me that the hard question is how one can strike the right balance. That is, take seriously the idea that terrorism is a threat to the United States, but without thinking that therefore we throw everything else out on the other side, and sort of finding how we bring these things together. I don't think there's ever going to be a kind of a perfect answer to that, but I do think that there's something to be said for trying to figure out ways to deal with terrorism. It's a very insidious force in the world today, and I think that one of the problems, for me at least, is that when we do, and I use we very loosely here, when we do a lot of the things that we do, we sort of take away the possibility of doing better things that would be more effective and less destructive of some other values.
Well, in fact, this book makes the point that not everything in the Patriot Act is bad. I mean, there were clearly problems, and one of the problems was a barrier between foreign intelligence gathering and the domestic criminal investigations. Information was being developed on the domestic side that wasn't getting shared because of our desire to protect the two, to keep the two separate and protect civil liberties. But the point that information wasn't being shared with foreign intelligence services that might have helped spot the conspiracy. But he adds very quickly, what has happened in the Patriot Act is that they've completely gone the other way and overreacted in their effort to make it good now.
John has one.
You've talked briefly about the destruction and our non-keeping of records as a way to avoid the Patriot Act, and also Professor Buss spoke briefly about the contents of the act, and I think when Congress gets through reading its own act, it may want to, or may be prompted to add some amendments and perhaps get to the area that we're discussing today. But the thing I wanted to direct my attention to was the balancing between the Constitution and this act as it's now passed. And your analogy is that there has to be a balancing of the Constitution against the requirements of the statute. And my question is, how is anyone going to get standing to attack the Patriot Act as an individual citizen, which you would need to bring the Fourth Amendment question before the court? And if it's done in secret and only the executive branch is involved, it seems to me the only outlet would be for a court on its own volition to say, I can't do this, I'm acting without jurisdiction because the parties aren't before me, and I can't act unilaterally. And the other would be that some person on a case-by-case basis say my rights of privacy are affected, whether that be the bookstore or a private citizen. And I just wondered what you would think in this regard, some contract to a bookstore where I say if I'm going to purchase a book, I want my records kept confidential if you maintain any. And that would give to me the bookstore standing perhaps on a declaratory judgment, but at least if he was in face of the subpoena and courage enough, he could attack that on a case-by-case basis. Otherwise, your separation of powers and then the unreasonability of search and seizures, it seems to me, is out the window in approaching this.
Well, the separation of powers, of course, I think that's not something that, for the most part, we can enforce through litigation, and I think Jackson is totally correct there. If we don't have a Congress that takes its responsibility and in the heat of politically controversial positions, that I frankly nothing scares me more than this kind of centralization of power in the president and the few people around him. I just absolutely think that is the worst thing that's happened since 9/11 in this country. But I don't think there's any good way to attack that in court. There is, certainly, in fairness, if you think about it, we have tremendous freedom in this country politically. There's nothing that stops us except money and will and things like that from a political campaign for running for office, for getting people to run for office that take a different position. It's hard to do, but that's out there. On the question about the Fourth Amendment is an interesting one. I would think that as is often the case, the only people who can challenge the unconstitutionality of a statute are people who violate the statute. And so, it would take someone saying, I'm not going to clam up and not tell anyone about this. I am going to call my lawyer and I'm going to tell him that I have had to do this and it seemed wrong. And then someone the government may come after that person, and then the constitutional fight would be on. I just want to say, doing that, my guess is there's not a person in this room that would want to be the defendant in that case. It would be an emotional, wrenching, expensive experience that would sort of take over your life for at least for a short period of time. Learned Hand once said there's nothing worse than death or extreme sickness than being involved in a litigation, and I think that in particular that kind. And so it's doable, but there's a huge cost. I'm sorry, I didn't mean to.
No, I was going to say. The bookseller in Colorado spent 2 years of her life, fighting this case up to the Colorado Supreme Court, and she won, and we paid her attorney's costs. But it was still 2 years. It was still 2 years that she couldn't devote to her business, and she'll never be compensated for that.
No one gave her an insurance policy in advance that she was going to win.
Right.
She was also invited to be here, but she couldn't. And actually, earlier in the week, she was given an award with also Lawrence Ferlinghetti, who created a Patriot Act poem of some sort, which I haven't read, but this is in Los Angeles for doing this. I think we're going to stop now, and we can all chat on our own later, but thank you all for coming, and we had no model to set up for this. We didn't know exactly how this was going to go, and I think you did a good job. Thank you.
Thanks.